In this lecture, we're going to be covering chapters 4, 5, and 6 of our Medical Law and Ethics textbook. Chapter 4 discusses working in today's healthcare environment. Major changes since 1965 with Medicare and Medicaid include increased life expectancy. So we have more older adults now than in any other time in our history. Technological discoveries, preventive care, and patient education are stressed more now than they have been in the past, even though they're not funded. And legislation and government regulation have made major changes in today's healthcare environment. Fixed payment plans, medical care for a fixed monthly fee or third-party payers, managed care or an MCO, which is a managed care organization, has a gatekeeping function. Health maintenance organizations, or HMO, offers a wide range of services to members for a predetermined fee by a limited group of providers. Managed care, preferred provider organization, or PPO. A patient must use a medical provider who is under contract with the insurer for an agreed upon fee. There's going to be a copayment. Exclusive provider organization, or EPO, combines the concepts of HMOs and PPOs, fee for service, or FFS. Medicare is health coverage for elderly or seriously disabled or with end-stage renal disease or other debilitating ailments, regardless of wealth or income. With Medicare, we do have a rationing of the healthcare services provided. Other federal assistance programs include diagnostic-related groups, or DRGs, classifies each Medicare patient by illness into a category. Hospitals receive a preset sum for treatment of an illness category, regardless of quote-unquote bed days used. Diagnostic-related groups, or DRGs, discourages treatment of severely ill patients. Patients often are discharged before they're ready. Medicaid is a joint federal and state program where the federal government pays approximately 57% of the expenditures, and the rest is paid by the state. Federal program implemented by individual states. Medicaid provides financial assistance to ensure poor and indigent people receive at least basic medical care. Rationing does take place. Not all providers accept Medicaid coverage. Individual states enact their own legislation regarding the spending of Medicaid dollars. Ethical considerations of managed care. Some physicians will not treat Medicare patients. If they do treat a Medicaid patient or a Medicare patient, they must provide the minimum standard of care to everyone. Patients must be fully informed of the consequences of obtaining health care elsewhere. Bait and switch. Profit may be more important than patients' health. Wealthy may have greater access to care and treatment than poor patients. These are ethical problems that arise with managed care. The Health Care Quality Improvement Act, or HCQIA of 1986, was passed out of concern about medical malpractice. It's designed to protect whistleblowers. A National Practitioner Data Bank, the NPDB, has information not disclosed to the general public. Types of medical practices: a solo practice, which is a sole proprietorship; medical partnerships, where shared responsibility for financial and legal matters is distributed among the various partners; associate practice, a shared facility but not accounting or legal responsibility; group practice consists of 3 or more physicians that share the same facility, practice medicine together. It can be designated as an HMO or an IPA. Professional corporations managed by a board of directors. The directors are elected by the shareholders of the corporation. One of the major benefits of operating as a corporation is the protection that it provides the members of the corporation from litigation that could impact their individual assets. Liability is limited to the liability of the corporation. It does not extend to the individual. Ethics of fee splitting. Fee splitting: one physician offers to pay another for referrals. This is unethical and illegal. Fee splitting versus referrals. The ethics of fee splitting: franchise, a business run by individual to whom the franchisor grants exclusive rights to market product or services in certain market areas. This is ethical. Franchisees, that would be the person or companies that hold a franchise. Medical specialty boards, 23 specialty boards which seek to improve quality of medical care, encourage physicians to further educate and train, evaluates candidates who apply and pass the exam, and board certifies those who meet all the requirements. The American College of Surgeons is a medical specialty board. Fellow American College of Surgeons, FACS, American College of Physicians, Fellow of American College of Physicians, FACP. Allied health professionals. Licensed personnel include a registered nurse, nurse practitioner, licensed practical nurse, and pharmacists. Certified personnel include physician assistant, medical assistant, medical transcriptionist, lab technicians, and lab technologists. Other registered personnel include nurses, medical assistants, medical technologists, and phlebotomists. American Medical Technologies AMT Association. Conscience clause enacted by several states. Employees may have a moral or religious objection to assisting with certain procedures, such as sterilizations or abortions. Employees cannot be discriminated against under this state statute. That concludes Chapter 4. Chapter 5 discusses the physician-patient relationship. Both must agree, the physician and patient, to form a relationship for there to be a contract for services. Under a contract for services, the patient can expect the doctor to provide medical service for as long as necessary. The patient must confide truthfully to the physician. The physician is not liable if critical information is withheld. Patient information is confidential. Doesn't matter how one comes into possession of that information, whether it is overheard or read. It's always going to be deemed to be confidential. Physicians' rights: the right to select patients, the right to refuse service to patients, the right to determine types of services provided, the right to be paid for services rendered, the right to withdraw from the physician-patient relationship, and the right to vacation and time off. The AMA's statement of principles includes human dignity, honesty, responsibility to society, confidentiality, and continued study. AMA's statement of principles further includes, in regards to physicians' responsibilities, the freedom of choice, responsibility to improve the community, responsibility to patient is paramount, must support access to medical care for all people. A patient's welfare must come before and above financial interest. Physicians have a duty to be courteous, to report any unethical conduct by other physicians, and to recommend second opinions when necessary. Physicians do not engage in sexual conduct with a patient during the physician-patient relationship. They do not treat family members except in emergencies. Professional practice responsibilities: duties during a medical emergency. Cannot ethically or legally turn away a patient in an emergency situation. If unable to treat a patient, then the physician must call for emergency assistance. Patients cannot be turned away if indigent or uninsured. In regards to the duty to treat indigent patients, dumping crisis, the EMTALA requires patient stabilization in an emergency. Physician has a right to select which patients to treat. Physicians do not have the right to drop or abandon patients once treatment is agreed upon. Once a physician agrees to take care of a patient, a contract may not be improperly terminated. A physician may be charged with abandonment if formal notice of withdrawal is not given. This could result in a civil lawsuit, or as we've learned, it's referred to as a tort. Physicians must allow a patient time to seek service from another physician. Licensed healthcare providers are also subject to this principle. Dentists, physician assistants, nurse practitioners. Non-compliant and or incompetent patients. A non-compliant patient is one that fails or refuses to cooperate, whereas an incompetent patient is unable to provide for his or her own needs. Oftentimes, a court must make the determination as to whether or not a patient is in fact incompetent. Duty to treat patients with AIDS. It's unethical to refuse to treat, work with, or provide housing for a person who is HIV positive or has AIDS. Physicians by law must make full report to state about any patient who is HIV positive or has AIDS. They must make this report regardless of consequence. Some ethical considerations: persuade the patient to inform his or her partners, notify authorities if concerned that the patient will not inform others. As a last resort, notify patient's partners. Exposure of healthcare workers to patients' blood. 0.3% risk of contracting HIV after blood exposure, according to the CDC. HIV testing of patients' blood allowed in some states. Restrictions on HIV-infected healthcare workers. There are various recommendations but no rules. These rules are provided by the AMA, American Academy of Orthopedic Surgeons, Federation of State Medical Boards, which provides the strongest statement, recommends names of HIV-infected healthcare workers be reported. Various recommendations but no rules. The CDC, testing all healthcare workers would be prohibited. No ethical duty to disclose HIV status if no significant risk is presented to the patient. Identify patients both with stating his or her name and examining any other identification, such as an armband, a driver's license. Use discretion with patient sign-in sheets to protect confidentiality. Have the patient state his or her name, but there is a duty to properly identify the patient through those means. Duty to respect confidentiality. You should speak in a low voice. Glass enclosure should separate front desk receptionist from waiting room. Sign-in sheet should consider protection from subsequent patients. The duty to tell the truth. Many believe principles of justice apply when dealing with truth-telling. Try to determine the just action for a patient. Just action may be at variance with one's obligation of confidentiality. Confidentiality may be overridden when life or safety of a patient is in danger. Patients' rights, the right to confidentiality, privileged communication, the right to give informed consent, the right to privacy, the right to be informed of advantages and potential risk of treatment, and the right to refuse treatment. All information and records about treatment will be kept confidential by the physician and staff unless consent to release the information is obtained. Breach of confidentiality is both unethical and illegal. The Medical Patients' Rights Act. All patients are entitled to have privacy respected and medical records handled confidentially. privileged communication, confidential information told to a physician or attorney by a patient. HIPAA regulations must be observed. We'll discuss that more in Chapter 10. Patient self-determination acts, advanced directive, such as a living will, for example, do not resuscitate order, durable power of attorney, uniform anatomical gift act. Patient may revoke these documents. Family may consent on the deceased patient's behalf. Definition of minors. A minor is a person under the age of maturity. The age is 18 in most states. In loco parentis is a person assigned by a court to stand in place of the parents. Parens patria is where the state takes over care for a minor. Mature minor is a person in his or her mid to late teens who, for health care purposes, is considered mature enough to comprehend a physician's recommendations and give informed consent. An emancipated minor is a person in his or her mid to late teens who legally lives outside the parents' or guardian's control. Proof should be included in medical records. The patient's responsibilities include following the physician's instructions, make follow-up appointments and monitor treatment and medical use if requested by the physician, be honest, pay for medical services, and provide informed consent. Consent is the voluntary agreement by a patient to allow medically trained individuals to touch, examine, and perform treatment. There are two types of informed consent: informed or expressed consent and implied consent. The doctrine of informed consent: informed or expressed consent, the patient agrees to course of treatment after being told consequences of having or not having certain procedures and treatments conducted. A signature indicates the patient understands limits or risk involved as explained by the physician. Requires the physician to explain in understandable language the diagnosis, the nature of the proposed treatment, advantages and risks of the treatment, and alternative treatments available to the patient. It requires the physician to explain in understandable language potential outcomes of treatment and what might occur, risk and benefits, if treatment is refused. The patient indicates consent by behavior that he or she accepts the procedure. For example, the patient offers his or her arm to have a blood sample drawn. Consent is assumed in medical emergencies when the patient cannot respond to give consent. Exceptions to consent: no need to inform of commonly known risk, no need to inform if disclosure of risk may be detrimental to the patient, no need to inform or obtain consent if the patient asks physician not to disclose the risk. Other exceptions to consent: not required to restore patients to original health, cannot elicit cure for every patient, cannot guarantee successful results of every treatment. Refusal to grant consent: adult patients, conscious and mentally capable, have the right to refuse any medical or surgical treatment. Refusal must be honored no matter what the patient's reasoning. Failure to respect the right of refusal could result in liability, both civil and criminal, for assault and battery. The role of healthcare consumer: do not self-medicate. Again, be honest with your physician and assist the physician in prevention of medical errors. That concludes Chapter 5. Chapter 6, we discuss professional liability and medical malpractice. Malpractice occurs when professional misconduct or demonstration of an unreasonable lack of skill which results in injury, loss, or damage to the patient. Professional negligence and medical malpractice. Negligence is an unintentional action that occurs when a person performs or fails to perform an act or action that a reasonable person would or would not have committed in similar circumstances. Malfeasance is performing a wrong or illegal act. Misfeasance is improperly performing an otherwise proper or lawful act. Nonfeasance is the failure to perform a necessary action. The 4 D's of negligence: duty, responsibility established by the physician-patient relationship; dereliction, which is the neglect of said duty; direct or proximate cause, continuous sequence of events unbroken by any intervening cause that produces injury and without which injury would not have occurred; and then damages, injuries caused by the defendant. Preponderance of the evidence is the burden of proof in most civil cases, where one side must demonstrate a preponderance of the evidence or a greater weight of evidence than the other side. Res ipsa loquitur means the thing speaks for itself. 3 conditions must be present in order to use this legal doctrine. Injury could not have occurred without a negligent act. Defendant had direct control over cause of the injury, and a patient did not and could not contribute to the injury. The example given to me in law school was if an airplane exploded in flight, that is going to trigger the doctrine of res ipsa loquitur, because airplanes are not supposed to do that, and therefore there must have been some type of negligent or intentional act to cause that to happen. Damages, different categories of damages: compensatory damages, which are court-awarded payments to make up for loss of income or emotional pain and suffering. Punitive damages are damages that are designed to punish the defendant in the hopes that it would deter that type of conduct in the future. It's an exemplary damage that can be awarded. It is a monetary reward by the court to the person harmed, where the defendant acted intentionally, maliciously, and willfully, and therefore their conduct needs to be punished. Nominal damages are slight payments awarded by the court. Fraud is the deliberate misrepresentation or concealment of facts from another person, or unlawful or unfair gain. This is one of the fastest growing crimes in healthcare. Medical assistants have been involved in several fraud cases in the medical office. None have been charged so far. The Office of the Inspector General protects federal programs from fraudulent activities. The Department of Health and Human Services, which oversees Medicare, Medicaid, violation of statutes, and whether there is immunity for charitable organizations. Defenses to malpractice lawsuits: affirmative defenses would include denial, assumption of the risk, contributory negligence, comparative negligence, borrowed servant, the statute of limitations, and res judicata. These affirmative defenses would allow the defendant to present evidence that the patient's condition was a result of factors other than negligence. Denial defense: the plaintiff must prove the defendant did a wrongful or negligent act. This is the most common defense. The jury must determine if the defendant was in fact negligent, may bring expert witnesses. In the medical field. There is almost always going to be expert testimony because we have to be able to show what the standard of care was and whether or not that standard was breached. Assumption of the risk prevents a plaintiff from recovering damages if the plaintiff voluntarily accepts a risk associated with a certain activity. The plaintiff must know and understand the risk involved, and choose to accept the risk must be voluntary. One should obtain a signature to a document that the patient authorizes the procedure, understands the risk, and consents to treatment. With contributory negligence, conduct on part of the plaintiff that contributes to the cause of the injuries will bar recovery of damages by the plaintiff. So, if the defense in a state that practices or recognizes contributory negligence, if the defendant can show that the plaintiff in any way contributed to the injuries the plaintiff sustained, the plaintiff will not receive any monetary award. Whereas in a comparative negligence state, the plaintiff's own negligence that helped cause the injury is compared to the negligent acts of the defense. So it is not a complete bar to recovery of damages. The plaintiff is allowed to recover damages based on the amount of the defendant's fault. So if the defendant is shown to be 50% at fault for the plaintiff's injuries, then the plaintiff's award of damages will be reduced by 50%. Borrowed servant: this is a special application of the doctrine of respondeat superior. Employer lends an employee to someone else. Employee remains, quote unquote, the servant of employer, but the employer is not liable for any negligence caused by an employee while in the service of the temporary employer. Ignorance of facts and unintentional wrongs: healthcare professionals should understand what is right and wrong under the law. Arguing that a negligent act is unintentional is not a defense. Statute of limitations sets a time period for an injured party to file a lawsuit. There is an exception, which is the rule of discovery, meaning that the statute doesn't necessarily start to run until the plaintiff discovers that they are in fact injured. Statute of limitations does not begin to run until the injury is discovered. It will not begin to run if fraud, some deliberate concealment of the facts from the patient, is involved. Res judicata means the thing has been decided or a matter decided by judgment. Once the court decides a case, the plaintiff cannot bring a new lawsuit on the same subject. In other words, the plaintiff only gets one bite at the apple. In civil liability cases, The physician may be sued under a variety of legal theories. Physical conditions of the premises. The institution may be liable when regulatory standards have been violated. This is also referred to as premises liability litigation. The illegal sale of drugs is going to lead to civil and criminal cases. A promise to cure, that's going to be considered part of the contract, and so if you make a promise to cure, there's could be a breach. Law of agency is a legal relationship formed when one person agrees to perform work for another. Altered medical records. Federal rules of evidence and the Uniform Business Records Act prohibit records to be altered, and that in and of itself could lead to a professional liability lawsuit. The employer may not have done anything wrong, but may still be liable under the doctrine of respondent superior. Liability insurance is a claims-made insurance, covers the insured party for claims made only during the time period the policy is in effect. Occurrence insurance covers the insured party for all injuries and incidents that occurred while policy was in effect, regardless of when the claim was made. Malpractice insurance covers any damages the physician employer must pay if he or she is sued for malpractice and loses that lawsuit. All licensed and certified medical professionals should carry malpractice insurance. It is an expensive type of insurance, and it does lend to doctors practicing defensive medicine. Some legal disputes will be handled in ADR, or alternative dispute resolution. This is a couple of methods where cases can be resolved outside of court. Arbitration is one way that a legal dispute can be resolved outside of court. This is where a person is appointed to hear the case, usually a retired judge, and whatever decision the arbitrator makes binds both parties. Sometimes arbitration can be conducted by one person, or there will be a panel, such as 3 arbitrators who will hear the matter. Mediation is probably the most commonly used form of ADR, and this is where a person comes in, a mediator, and meets with both parties in an attempt to get them to resolve their dispute. The mediator does that by pointing out the strengths and weaknesses of the other's case and tries to help find the middle ground so the case can get settled. But whatever the mediator says is not binding on the parties. Medical arbitration is another method to resolve disputes. It's a combination, med-arb is a combination of mediation and arbitration. Liability of other health professionals, dental assistants, laboratory technicians, medical assistants, nurses, nursing assistants, paramedics, pharmacists, physical therapists, physician assistants, respiratory therapists. Many states have passed tort reform or malpractice reform. 32 states have passed these types of reforms. It places limits on a plaintiff's ability to sue, and it caps the amount of damages a plaintiff can recover. This is an arbitrary way of limiting any type of lawsuit, because it's very difficult to put an arbitrary cap on damages, because how do you arbitrarily decide one's pain and suffering, for instance. Some malpractice prevention techniques, general guidelines, safety, communication, and documentation. That concludes Chapter 6 and concludes this lecture on Chapters 4, 5, and 6 of our medical law and ethics class.